On today's episode, I sat down with Rich Goldstein. Rich is a career patent lawyer, having studied both engineering and law, making a very unique combination in understanding what it takes to bring a patent and therefore a product to market. I really dove in asking questions around the value of what does that bring to a business upon exit and during the lifetime of the business while owning products. How does that really help you protect against potential competitors coming in? And for me, it was really fascinating. It's a topic that is, in my opinion, not talked about enough, but something that can really set you up for success when it comes to building and potentially selling businesses. So I hope you take what I took from this episode. Enjoy. Hi, and welcome to Successful Scales, the show where I interview now successful professionals about their journey and try and garner insights onto any tips that can be applied to your business at home. Whether it's financial freedom or the exit of your company, wherever your journey may take you, the idea here is to simply learn from those who have done it before. I hope you enjoy and you get some value out of this. Buckle up and enjoy the episode. Rich, welcome to an episode of Successful Scales, my friend.
Hey, thanks so much.
Yeah, I mean, we have literally, I feel like I've known you for a lifetime and we've only probably sat down for a couple of hours now, but it's been amazing getting to know you.
Yeah, likewise. Absolutely. And I'm so glad to be on your show here today.
That's fun. Well, like I said, really just grateful to have you here. And I think that, your position and what you do today is super interesting, relevant, and very current, and something that I think more and more, when you talk about the rise of the aggregators and the value that businesses have, so much of it is inside of that intellectual property and that effectively that massive differentiator. But before we dive into the current state, I'd love for those listening at home, and honestly for me as well, I'd love to find out a little bit more about your history and sort of what's led you to the point where you sit today.
All right, cool. So about my history, anything particular
well, just
about my history?
Professional. Let's keep, I know we were saying we could probably have a conversation for 6 hours and do 45 episodes together, but let me narrow the field. So professionally speaking.
Sounds good. Well, I mean, I started out by studying electrical engineering. Realized that becoming an engineer wouldn't be as interesting as I thought it was going in, that you're really working on a minute portion of a product for years at a time. And I found out about patent law, and which involves being a lawyer. You need to be an attorney, of course, but you also need to be an engineer to understand the technology. And so I finished my electrical engineering studies and went on to law school. And then I did something unusual. I opened up my own practice right out of law school. So I never had a job at another law firm, as a lawyer, right? I mean, I worked for a summer during law school at a law firm, but that was it. That was enough to tell me that I never wanted to work at another law firm again. So created my own law firm right out of law school. And 27 years later, I'm still here.
Wow. I mean, already so many interesting decisions that you made in such an early point in your career. I mean, it is very atypical to go straight from, usually it takes people sort of 4 or 5 years to realize that they weren't built for practicing law. So to make that jump effectively and really sort of honing in. I mean, what was that?
I realized they weren't built for working in a law firm, and to develop the contacts and to have some clients so that when they do go hang up a shingle, they have some money coming in and not just starting from nothing. So yeah, that's more typically how it's done.
Well, yeah, I mean, absolutely. And I think I find that super interesting, having the engineering meets law background. I mean, inside of our consulting practice, I would say the bulk of talent that we have are industrial engineers, because of how sort of, how would I put it? Like very systems focused.
A certain way of thinking, right? About things.
Absolutely. So to have that coupled with law, I think also there's similarities that exist between the two, but super interesting. Wow. I didn't realize that was your background. So I'm glad to I'm glad to hear it. But it sounds like, you would define yourself, or I'll define you, I'll put it out there. Pretty much that's super entrepreneurial to go down what is extremely to, not clinical necessarily, but very typical, go to law school, go to become an engineer, and now you're
Yeah.
effectively starting your own business. I mean, how
Yeah,
did you
two
even approach that?
professions, which are very much usually about like just being part of the system, like working in the framework, like being part of an engineering firm or being part of a law firm. Yeah, I mean, and yet there's been this entrepreneurial part of it. So it is kind of, it definitely has been quite interesting.
How is that received? I mean, I know we're going back a few years now, but how is that received? If surely your parents are super happy. You've studied law, you've studied engineering, you've got
Oh,
all the
yeah.
markings, and then you decide to start your own business.
Not well, was not received well. Like I remember actually start my a friend of mine, like my best friend, bumped into my parents around that time, and they were telling him like, don't you think you should get a job, don't you think you'd be better off, like don't like they expressed a lot of concern to my friend. I'll never forget that. And basically, yeah, it was not. And my parents are relatively low risk type people also. My father worked as an engineer for the city of New York his entire career. He worked for the city of New York, and my mom, worked at the post office. Kind of like for about 15 years up into retirement. So, relatively low risk type people. And for me to give up what they perceived as like, well, that's the dream job, making six figures, working at a law firm, and, like, why would you give that up? Like, I didn't want to work 80 hours a week. And I didn't want to kind of be beholden to others that had just a very different way of looking at things than I did. So, yeah, it was definitely not um, a well supported choice, but it was, it definitely was one that I was determined to make.
Yeah, and I think that that's probably something that, when you go down that path of entrepreneurship, that it's seldom spoken about, but one of the more challenging things is that perception of the risk versus reward. And, most people are going to take on that traditional 9 to 5 and climb the ladder. And I was there as well. I spent, unlike you, I spent 10 years doing it. I worked for people. I would say that I got a lot of my extremely valuable learning through that process. But I think that even when you make that jump, whatever point of the career it is, it's always met with some degree of, I mean, there's obviously uncertainty attached to it, but there's always that degree of, are you making the right decision? How hard was that for you to, and I'm imagining as well, you're going back.
Yeah, and for me, it was just natural. It was like, yep, this is what I'm doing. And at the same time, I also was involved in launching a magazine for inventors. So I had a lead gen pathway. I was putting out a magazine for inventors, and advertising my law firm in that magazine. So it's like I was doing content marketing in the 90s in print form. So so I kind of had a whole scheme set up. So I was all in. There was no hesitation on my part that I was making the right choice. I had decided the previous summer working at that law firm that they're like, no, this is it. I am not ever going to do this again.
Wow. I mean, it's just incredible to meet people who actually make that very calculated decision so early in their careers. Got to say, it's got more balls than I have in terms of jumping in head
Right, or
first.
less, something like that.
Yeah, yeah. So, I mean, 27 years on now, what does
Mhm.
life look like in terms of your operation? Like, help me understand a little bit about what, we had some great
Yeah.
conversations that I want to dive into, in the last couple of hours we've been chatting, but yeah, what does it look like today?
Yeah, I have like 10 people on my team. And what does it look like? It looks like, it looks like a good amount of this, what we're doing right here. I spend a good deal of my time on podcasts or other people on my podcast or on webinars, speaking at events. I'm kind of um, the brand for my law firm. So I spend a good amount of time doing that, building relationships in general, building relationships with people, a good amount of time and attention then focused on lead generation, and also then directing the team, like directing the team, running the team. I do work with my clients directly. I'm not necessarily doing the work, probably not doing the work, but I am figuring out what needs to be and then making sure it gets handled, making sure it gets done in that way. So I'm kind of spending time with clients on strategy. And that's mainly what my day is like. I'm not in the trenches writing patent applications anymore, like I spent a lot of my career doing. So yeah, it's basically like anyone else running a business. It's like you run the business that you delegate what you can to people that are on your team. You handle the things that are not delegable, or at least at this moment or with this level of scale, right? And then you look for opportunities for bringing more people onto your team to handle those things that then could allow you to move up to the next level.
Yeah, I mean that is the way to approach scale, absolutely. And there's those aspects that you have to have a strong enough handle of for you as the operator as well. You're not going to simply delegate out tasks that you have absolutely zero idea about, especially as a business owner. So yeah, I can totally relate to that. But you know what? I'm going to take this opportunity to be, well, I don't know if it's selfish, but it's not every day that I get to sit down with someone who is at the forefront of what is an ever-changing and a super exciting time in the e-commerce and Amazon space in particular, to ask questions about intellectual property. And so, I'm very fortunate that I get to spend a lot of time speaking with people just like you do, and I devote a lot of my time to the same things around having podcasts and having super stimulating conversations with people in all walks of life. But I'd say one of the things that's come up a ton lately is just how frequently Amazon businesses are being sold to aggregators and venture capital and strategics and the likes of anyone that's acquiring. It's a real seller's market, I really feel, at the moment, in that you're seeing multiples continuing to go up. And I've always wondered, not ever having a patent related to a business to date, and I dug in last time and I had so many questions for you, the challenges around a service-based business and how do you actually effectively protect that IP. But what are you seeing when it comes to companies that do have intellectual property and patents taken out, and how's that actually impacting, I would say, their business on the day to day? What, as me as a potential e-commerce seller, what does that look like? And for those who are looking to exit, I mean, how much can this really impact their business when you're talking multiples and exit value?
Yeah, absolutely. And I think that's a good way to divide it up too. It's like, how does IP affect the day to day? And then how does IP affect the exit? And like, to me, those are the two major buckets of where you would look to measure the impact. And I'll just simplify it by saying that the IP may or may not affect your day to day. In other words, it may give you some ability to stop competitors, to to gain an ROI from the IP based upon your ability to stop competitors. But it almost certainly will be valuable at exit. So it's like, those are the two dividing points. And it's like, when you're running a business, it's hard not to look at how any particular expense affects your day to day, because really, during the running of your business, during the operation of your business, IP is plainly an expense, right? It's an expense. And like, you always measure the expense with what the benefit is that it's providing to you. If you're spending money on PPC, how much is it helping sales? If you're spending money on a certain consultant, how much is that affecting kind of your ability to get products out there, to sell products, et cetera. So you're spending money on IP, you're looking at like, so, okay, so if I'm going to spend money on this patent, is it going to tangibly affect my day-to-day? And so the way it could tangibly affect your day-to-day, obviously, is like if you're selling $200,000 worth of product, and then suddenly a bunch of competitors come in and they take a quarter of your market share, then that's $50,000 a month. So if you're able to shut them down because you have a certain patent or a series of patents or with some IP, then that IP is worth $50,000 a month, plainly. It's not always that we get to see that, though. It's not very often that we get to see that type of measurable result, where at exit, it's a different story.
Well, I can say, being on the receiving end, the Amazon business I was working with that was effectively sold, one of the owners, one of the original co-founders of the business, was not the most adept to doing serious research. And so there was a product we were selling that, we were selling this kid's lap tray. There was a patent on, I don't know, the stitching, I don't even know what it was, to be honest with you. And off you go. We had this whole dispute with Amazon. In the end, we just decided it's not even worth fighting it, because for the time that it's going to be down, let's give up. And we did a removal order and we got on with it. And so, I can say unequivocally, had a hugely positive impact on that person's business and totally destroyed any revenue or any way that we would have recouped anything that related to that particular SKU. So, definitely.
And that happens, but it's not the most typical thing. Like this is what people are looking for when they're going to invest money into IP. They're really thinking in terms of that type of scenario. Like, is it going to tangibly affect my bottom line as I'm operating? And they're not looking to this whole other area, which is like, well, how's it going to affect the purchase price when I sell my business? Or how is it even going to affect whether the purchase whether the sale can be made, whether I can sell my business? And yet that is often where it has the biggest impact, is right there at the moment of that you are exiting your business that you're selling. Is like that having the IP and not having the IP can be the difference, significant amount of valuation, and it could be the reason why someone else passes on buying a company. They say, well, you don't have the trademark protection for the brand, so they're not going to buy it.
And so, as someone, like I said, who's selfishly going to take this opportunity to ask a series of questions about,
selfishly on behalf of your audience. So that's not really
exactly. You're right. I'm sure if I've got these questions, and typically a lot of people will as well.
You don't want to talk more about my background?
Well, back to engineering. So
I've got a lot of great stories, but we'll talk about those another time.
I can't wait to hear those. Listen, I mean, you're a slick guy to be creating that form of marketing back in the 90s. I can only imagine some of the stories that I'm sure we'll share over hopefully a few beers at Prosper next month.
Absolutely. Yep.
But while I'm being selfish for myself and the audience, I will ask the question that I think a lot of people sort of getting into, a lot of people look at getting into Amazon. It's the easiest. It's easy. I'm just going to dive right in. I'm going to find a product. I'm going to go to AliExpress or wherever else I'm searching, and off I go. And I think that, the risk when you're starting to run a business and you haven't done your due diligence on what exists in market, what are the potential complications, what are my perceivable realities when it comes to my appetite for how much risk there is. I mean, how do you even start the process? Let's say I've gone down the path, I've identified a product. How do I know that I'm not going to come up and hit that brick wall that we hit selling a product that someone else has a patent against?
Well, I would say you don't know. Like you really, when you're starting out small, you don't know if you're going to hit that brick wall. I would say the biggest the biggest thing you can do is to use common sense. Is like, you know, if you know you're copying a product, then you know, imagine that there might be some IP to it. That you're better off going for something that has been around, is more established. It's a product that maybe has been on the market for 20 or 30 years, and you kind of can pretty much rest assured that you're not going to be infringing a patent. Like that, again, using common sense. Also using common sense. It's like you want to sell a product and you want to make it look just like a competitor's and have a brand name that sounds just like their name, because you're thinking like, okay, well, they'll buy mine by mistake. Well, you're probably walking right into a trademark problem there. And it's, again, it's common sense. If you think that you're doing something wrong, you probably are. It's not always actionable. It's not always something that they can take action from. Not every type of copying is going to land you into trouble. But that's one of the ways to minimize your risk, is to use some common sense about it. And I'd say too many people don't.
So you said something before, and I think I'm picking up what you're putting down, but you said that you pick products that have been around for 20, 30 years. Is that because the patent expires over a period of time?
Yes. Exactly. So if you're going to sell like a product that has been out there, let's say for 30 years, you can know pretty safely that there's no patent on that product. Whatever was out there 30 years ago, it's not possible for it to still be patented, you know, for the same thing as was out then. It is possible that the improved version. Why is that? Because a patent lasts for 20 years after a utility patent lasts for 20 years after you apply for it. You need to apply for the patent. At least going back then, the law has changed just a tiny bit, but you need to apply for a patent within 1 year of the time it's publicly disclosed. So you can safely say that unless they applied for the patent, like, you know, 21, 22 years ago, then in which case the patent would have expired already, then they would have lost the right to ever patent it. So you know, the rule has always been, it's changed slightly lately, but the rule had always been that if you publicly disclose an invention within 1 year, you need to apply for the patent, or it's just in the public domain. It's open to anyone. So if you see a stapler out there from 30 years ago, you can safely say that if I want to make that exact stapler, I'm free to do so. But what you can't do is you can't copy any of the improvements that have happened along the way. So you notice that maybe for the last 5 years, there's been like staplers have had this kind of new release lever or something like that. It may be that there's a patent on that. You can't say that that's free for you to do, but whatever it is that had been done way back then, you can do exactly that. And by the way, the same thing goes for if you feel like hunting through the records of United States patents and you find one that's interesting and expired, you're free to do that. You're free to make exactly that product in that patent. So that's just one way to reduce the risk. But yeah, in general, like when you start, you know, when you know you're copying someone, you are running a risk. And I think that's the common sense that should enter into it. And it's rather difficult to determine when you're infringing and when you're not infringing. It's the most expensive and most difficult thing that anyone could ask me, is to say, well, I've got this product here. How do I know if I'm infringing anyone else's patent? Or can you find out for me, am I infringing anyone else's patent? That's called freedom to operate research, where you're really looking for the freedom to know that you can go out and make this product and not step on anyone's toes. But it's possible that any product, especially any somewhat involved product, could have patents on many different aspects of it. There could be a patent on the you know, the connector system, kind of like the lightning connector in an iPhone, or there could be a patent on the way the battery compartment is configured, or there could be a patent on some aspect of the circuitry, or the look of it, a design patent for the look of the product. There's so many different directions that can go in, that it's an extremely involved project to do a freedom to operate review. The one footnote I'll add to that is the extent to which you could limit the area of search, the way you could limit the type of info that a patent attorney would need to review to figure that out, that will help you tremendously. So it's like, if you know the product and you know the patent number, then that's going to make it a much narrower project than it's like, well, here's the product. I don't know what patents there are, but what am I infringing? That's a much more difficult project. That's easily 10 to 20 times more involved than if you just had an identified patent and you're saying, can you help me determine if I'm infringing, and is there a way around this patent?
So it's so funny. I'm sitting here and I'm literally, I think, I don't know if it's the way my mind works, and I'm thinking, well, how could I find my way around this? So what statute, maybe not statute of limitation, but what expectation is there on you, the patent lawyer, versus the governing body, US patents, who are actually reviewing it? Like, why couldn't I perceivably just say, right, I'm going to put this patent, I don't really give a shit if it exists or it doesn't, I'm going to submit it. They'll come back and they'll say, well, sorry, you're actually infringing. Why couldn't I have them do the work?
Oh, great question. And it's because you getting a patent is not a guarantee that you're not infringing anyone else. And so like when they're determining whether you can get a patent for your product, they're not looking at infringement. And I know this makes absolutely no sense. I'm going to make it clear in a moment. The reason it makes no sense is because people would say, well, okay, so wait a second. So if I'm close enough that I'm not going to get a patent, that must mean I'm close enough that I'm infringing. Or the opposite, though, is what they're usually thinking. Is like, well, if I'm different enough that I can get my own patent, that must mean that I'm different enough that I'm not infringing, right?
Yeah.
Doesn't work that way. I'll explain how, and it'll make total sense. It's like, imagine you invented a chair, right? You invented a chair with 4 legs and a seat. It's like, I guess it's more like a stool, but that's the chair that you invented. You're able to patent that. I come along a few years later and I invent a chair with 4 legs, a seat, and I add this seat back to it to make it more comfortable on your back, right? So I add the seat back to your chair. The patent office will say, well, you've made an improvement, and that improvement is worthy of a patent. So they'll grant me my patent for my chair with 4 legs, a seat, and a seat back. But I can't manufacture a chair with 4 legs, a seat, and a seat back without making a chair with 4 legs and a seat, right? So your patent is a sub combination of my invention. And therefore, I can't make my chair without infringing your patent. So, and that's often how it goes. When something is groundbreaking, then the patent on it is for the core combination of what makes it work. As time goes on and people improve upon it, they're able to get patents on their improvements. And, they still, though, could be infringing the original one. But there's something also that's important to understand about that. So the people that come later on, that they didn't have the original concept, they're getting a patent on the improvements. They are, their patents are going out into the weeds quite a bit often, where the improvement, it might not be that big of a deal. So it's like, okay, then someone comes along and they add, curved armrests that kind of like go straight across, then curve down in the front, and then the question becomes that now that they're getting a patent on the chair with these armrests of a certain configuration, does that matter to the market? Does the market care about your curved armrests? Or do the competitors look at it and say, well, we don't need the curved armrests? Then that patent's not very valuable. And this is the most important thing, I think, for people to take away, is that every patent has a scope. And some patents cover a whole concept, and some are very specific. before you invest money in a patent, you want to figure out which you're getting. Are you getting something that's going to cover, 4 legs and a seat, and then like you'll be able to shut down all the other listings because they can't make the chair without 4 legs and a seat? Or are you getting one that has just a lot of detail? In order to get the patent, you need to limit it to a lot of the detail of what makes yours work, but that's not necessarily things that other people are going to want to copy. Then you might want to think twice about getting the patent.
Yeah. I mean, my mind just goes to the most obscure places right now when I'm hearing you sort of explain the limitations. I'm sitting here thinking, all right, so this guy's got a great idea. He's had 5 years in market with this patent, 10 years in it. I'm not going to be able to, I'm not going to be able to claim it, but I'll make all these incredible upgrades. And then 5 years from now, 10 years from now, when it actually expires, then I'm going to absolutely crush it. And they're not going to be able to come to market with it anymore because now I've created all these upgrades,
Yeah, you
like,
could. You
like,
could.
and then the other thing I was
And you
thinking,
might even be able to do better than that too. Is like, so imagine like there's this core product that one company has the patent to, and then you come up with like a bunch of really cool enhancements to it. And then you go to that company and you say, look, I've improved upon your product in this really cool way. If you'd like to give me a license so I can make the chair of your patent, then I'll give you a license and you could include these improvements in your product. It's called cross licensing.
can you also, and then what's some of the other could I also effectively just broker a deal with someone who has the patent and say, hey, I want to sell this with the add-ons, and you give them some sort of a commission or whatever that sort of
Yeah,
fee
it's just
structure looks
that's
like?
a licensing agreement where you're just you're making a contract with the patent holder, giving you the right to make the product, or basically the right to not get sued by them while you're making the product, and in return you pay a royalty. And that's one outcome that can come out of these like scenarios on Amazon when you are found to be infringing someone else, is like you can work out an agreement with them like that. And I think Amazon, even in the in when they contact you, they say like contact the rights holder to make arrangements, because that's what they're hoping, is that you make arrangements and you continue to sell, and they continue to sell, and everybody's happy, and
Everybody wins.
so yeah, that's a possible way to do it.
I'll tell you, okay, it's great to know. And I'll tell you where else my mind went is that, at some point in time, someone who is really investing in their idea to the level where they've created a patent, why wouldn't I simply look 20 years back into areas that are interesting to me and then start to say, right, this is expired. This is a great idea. Someone's invested that much. That could be a whole new, I'm just thinking that's a whole new area where I can start to get product ideas.
It is a whole new area. I mean, I put together a presentation on that for Kevin King. You know Kevin?
I do.
Yeah. So for his $1 billion seller summit about a year ago, I did a presentation on how exactly you can hunt through the files of the U.S. patents to look for an existing product, and then how to make it your own. So yeah, there's definitely good possibility there. The one thing I would say about it though is you have to hunt through a lot of like so ideas to find some good ones. But one of the benefits is that, so when someone applies for a patent, they must provide enough detail so that someone in the field can essentially produce the invention from the description without too much experimentation. Like there's no dimensions typically in patents, and you don't have to say whether it's it's a machine screw or like a tapping screw or whatever. Like you don't need those fine details, but you need to give enough detail so that people in the field just know what it is and how it works. So any patent that you find will have that level of detail, because that's what they had to do. 50 years ago, they decided that this hair dryer concoction was something worth patenting, and they went to the time and trouble of fully explaining how it works, and it's all laid out for you right there in the patent.
Yeah, fascinating, fascinating. I'll tell you what I find also really interesting is that, when I think about the typical entrepreneur, right? They're head down, driving forward, trying to get whatever it is, we're talking products particularly, getting it up off the ground, right? And now there's a lot of moving parts when you're building a business, when you're building when you're building an Amazon business, an e-commerce business, you're going to the manufacturers, you're having to deal with supply chain and logistics, you're building the listings, you're looking to market the product. If it's outside of Amazon, you need to build email campaigns and landing page funnels and whatever it looks like. I mean, it's really endless, media buying, etc. You've only got 12 months to actually get a patent out on that product once it's been launched from, once it's visible, as I understand it, to the public
Yep.
market. How many people are going in with that level of education, knowing that they need to do this? And, I just think there must be an insane amount of people who have missed out on enormous opportunities because they just haven't got on this fast enough.
Insane amount of people. And that's why anytime I do a presentation, that's one of the things I want to hit on, because I know, I mean, just throughout my career, well, look, let's put it this way. As an entrepreneur, one of the primary things you need to do when you're launching a business is to preserve your resources and to make good choices about how you allocate your resources. And people very often, when they're launching a product, they'll say that patent sounds like a good idea, but it's very expensive. So I'll wait. I'll come back around to it. And often, what happen, what I've seen happen, is then they put the product on the market. A couple of years go by, things are going great, and they come to me and they say, "Well, I've got this product. It's doing phenomenally. I need to protect it." And I have to ask them the question that I don't want the answer to, which is, "Well, how long has it been out there?" And they'll tell me 2 years. And I'll say, "Well, it's too late. I'd love to take this project from you. Obviously you can pay to have this done, but I can't help you because it's just too late." And they'll often say, "Well, how would I have even known that?" It's like, you wouldn't. It's not like they teach about patents in high school. It's not like the required curriculum. So that's the one thing I always want to get across is this. And I'll just say it this way, is if you put a product on the market before you apply for a patent, you immediately lose the rights in most of the world. And in the US, where there's still a 1-year grace period, if a year goes by and you haven't applied for the patent, then it's game over. So there are other ways to lose out too. That's kind of like, assuming no one copies it and assuming no one else applies for the patent, because the US is now a first to file system. So the first person to file a patent application is the one entitled to the patent. So there's other ways to lose out, but assuming that no one else was even involved, no one else was even trying their own version of it, simply your own action of making it public is what could cause you to lose all of your rights, the right to ever patent it.
It's intimidating here. So, okay. So
Yeah.
I'm going to launch an Amazon business. I'm going to
Yep.
launch an e-commerce business. I'm relatively confident while I'm going through this process that what I've come up with is pretty good. And, I have every intent to sell in market. What stage in your mind is the right time to really start considering bring on a patent? Is it before I've hit day one and I'm like, well, I'm pretty confident without any backline insights, or is it 6 months in? Like what are you typically seeing is the right time?
Yeah. I'm glad you said what was the right time to consider, because that's how I would look at it too, is to really divide the line between considering and actually applying. Right. So I would consider it, and I would invest in looking into it before you launch. So like before you launch, you want to figure out, like, is this something that I can get strong protection for or not? Because first of all, in many cases, there'll be nothing that it's not possible to protect it. And then you don't need to bother at all. Then you can like kind of go forward like full force to get the product out there, knowing like it's not, it's not protectable. It's like so often like when people aren't protected, but they're still thinking about protection. they'll put one foot forward and one foot back, where it's like, okay, I'm launching this product. Oh, Oprah wants to have it on her show. And he's like, well, I don't know if we're ready for that. People might steal it, you know? So it's like you're kind of hesitant about it. But if you figure out at an early stage, there's no possible way to protect this, then you could just full force go out there in the world knowing that, like, hey, look, I'm gonna get it out there. I'm gonna do the best I can. And like, I don't have to like do it with hesitance, as if like, you know, I'm not ready to put it out there full force because I haven't protected it yet. So that's a good positive outcome, is to figure out no way to protect this. That's a good outcome. And then now you allocate your money towards marketing, promotion, getting it out there. Another possibility is that you might be able to get a patent, but by taking the right look at it, you get to see, like, you know what, I'm actually not going, wouldn't be a very good patent. It would be a patent limited to kind of having these features, and that's probably not very valuable to me. So I'm not going to bother with applying for a patent. And then another outcome possible, it's rare, but it's possible, is that once you look into it, you say, you know what, this actually be a very good patent. This would be a very strong patent that would preempt a whole new area here. So maybe I should put my resources into getting this patent now, or get some other resources from someone else, knowing that it's important enough to kind of call in that favor, or borrow some money from someone, or whatever you need to do to get it protected now. That's definitely the minority. But the way that you get to determine, well, which direction is right here. Do I never protect it? Is it like that I'm headed for something that's so-so in terms of protection? So maybe I do it later, maybe not. Or is it something that's like critical? Do it now, because the patent may be the most valuable thing that you get for this particular product. And so I say you consider it before you launch. You know what category you fit in. You know, and the way that you do that is by digging into what other people have done before, called prior art research. Once you know what the prior art is, prior art are things that have come before that are like your patent. Once you know what the prior art is, that's when you can figure out, can I get a patent on this whole concept? Or has most of this been done before and that I'm just getting something specific? So that's what you want to do. And that's when you want to consider it.
How, great insights, great information. How hard is it to find historic, you know, prior art or patents that have existed? Because I'm just thinking it's done, sounds like, by the US government or some body inside. Like, how much work are they putting into making that very easy and accessible to identify?
Yeah, well, I mean, there's different databases that are available for looking up patents. I mean, there's even something called Google Patents. You know, it's patents, patents.google.com. It's a search engine for patents, and so you can look up patents in that way. But there's some limitations to it in terms of effectiveness. It's like finding the closest things to it requires some skill, and it requires going beyond just doing a word search. You know, an example I like to give is like you invent a new type of can opener, and so you're going to Google Patents and you're typing in like can opener with handle release, right? Because that's what it has, some type of handle release lever or whatever. So you're searching for can openers. Google Patents is going to pull up a whole bunch of can openers. But if someone had the same invention as you and they didn't call it a can opener, but they call it a container lid remover, it's not going to show up in that search. So professional patent searchers use other methodology for finding things of the right technology that isn't necessarily using the same words. So just as an example, it's like the point is, like, you can do searching online and you could find some things out there that are like it, probably enough to tell you, like, you know what, this thing's way closer to it than I even thought existed. Like, let me not bother with this. Let me move on to something else. But if you do such searching and then you determine that there is that there doesn't seem to be anything that close to it, you still should do a professional search before you go into you dive ahead into filing a patent application. Because if um, you would spend far more money on applying for the patent than on having the professional search done. So it's a good place to start, but you don't want to skip that. And then probably more importantly than that is the strategy. Just, even getting a bunch of patents in hand and seeing what some of the closer things to it are is helpful. But I think the most important thing in the beginning is strategies to figure out, like, well, what's possible here? Like, can you do a patent? What patent should you be applying for? And I think a lot of people just really skip that strategic inquiry at the beginning that I think is so important.
Yeah, I feel like I've learned so much, and it's really funny. We were talking about like what's the length of the podcast. I'm looking up, and there's literally minutes left for us. We've just gone on and on about this, and I'm loving every minute of it because it's like every time you meet someone that has a very unique niche skill, it just is this entire world in and of itself. And so I'm particularly curious when it comes to the types of clients that you're working with. If I had to guess, I'd assume that you'd almost have these like serial patenteers, the people who are coming and effectively, jumping in from the get-go because they're understanding the impact of business. I mean, is that like it's like not a gateway drug, but you come in, you create one, you see the impact it had on the exit value, or that you could fight everyone off with a stick every time they tried to challenge you with their new product spring. Is that typically what you see happen, or
I mean, I see all kinds of things. I see all kinds of different clients, from individuals with just one idea that we work on together, and they're excited about that one particular idea, but that's all that we ever work on together. And I mean, a lot of inventors don't get very far with it. And then you have people, I also have bigger companies, not many, but I have some bigger company clients who obviously we've worked on project after project together. Um, and, but those people like you're discussing, those people that you're describing, the people that have actually played the game of IP and won, then they become true believers. People that have actually seen the value at the time of exit, then yeah, of course, the next business they come around, they start from the very beginning. Let's come up with an IP strategy. Let's start with something now, being that we're this size now, we're small now. Let's allocate a certain budget to IP, knowing that over time we're going to expand that and seek to get more and more of what we can, build an IP portfolio. But yeah, generally those people who've had those experiences, they become true believers. And some of those people are people that had a negative experience, people who had a few $100,000 in inventory and suddenly they had to eat it. They had to change the name of their company because they didn't do their due diligence with regard to the name of the company. And so now those people, time and time again, are doing the due diligence in the beginning. Either way, however you get there, is I think the bottom line message is to find an appropriate relationship to IP. It's not a relationship where IP is extremely valuable and the answer to everything. And it's not the relationship where IP is just a waste of time. It's something in the middle. And that's what I think is important to find as an entrepreneur, an appropriate relationship to IP so that you do the right thing at the right time when it matters.
I think that's extremely valuable words of wisdom as we're about to cut into the end notes here. So before I do let you go, Rich, I'd love you to tell me what's the best way for anyone who's going through this journey, whether they're at the start of it, have a product in market that's sub 12 months, remembering that, that's the end of it, which is really sad reality when I think about the hard work that's probably gone into people's businesses and what's happened there. But what's the best way for them to get in touch if they need your services?
Yeah, best way is to go through my website, goldsteinpatentlaw.com. And there are great resources there for learning about the patent process. And you also can set up a time to talk with my team to see if it's a match to work together. And I recommend too, like just really learning about the patent process. I've got a book that I wrote for the American Bar Association, explaining in plain English how this works. You can find that on Amazon. It's the ABA Consumer Guide to Obtaining a Patent. And also I've got a podcast where I have awesome people on that have been down this road, and they tell the stories of what's worked for them. That's called Innovations and Breakthroughs. So those are just all resources to help you on your path. But I highly encourage that you learn what you can, or that every entrepreneur learns what they can about IP, so that you can make good decisions when IP issues come around.
Well, I feel like I've started that journey now with you, mate, and I've learned a ton, but you've definitely got me hungry for more. And I think that it's definitely somewhere I'm very curious to see what ideas can be created from new business ideas, particularly around product-based businesses. So Rich, thanks so much for sitting down and taking the time out of your busy schedule to sit and help educate me and the listeners. So yeah, it's been an absolute pleasure. Thank you.
Yeah, my pleasure. Thank you for having me.